Hey,
You're good. We live. All right. Peace, everyone. Welcome. Welcome to the Moorish Investigative and Research Committee. All right. Today is September 28th, 2024. It is currently 3:28 Eastern Standard Time. We have the day's topic is the finding of facts, the use of affidavits and notary processes. So this is session seven of the Moorish Investigative Research Committee. We have the other 6 sessions on the Moroccan Post Media YouTube page. That's on the Moroccan Post Media YouTube page, along with a host of other classes. That's the Moroccan Post Media YouTube page. We can go to the next slide.
could you check it, man?
All right, so
See if you can find a pair of glasses.
all right, so we waiting for the other slide to come up. So it's welcome everyone. Welcome to the Moroccan Post, Moorish Investigative Research Committee, Session 7.
Check the car.
You have that up. All right, here we go. So we have here, we're in Session 7 today. The sponsors of the Moorish Investigative Research Committee are the United Tribe of Sovereign Moors and the Moroccan Post School of Government and International Law. Committee Chair, King Al Bey is the committee chair. Yours truly, Abdullah Il Talib Mosi Bey is committee advisor. Shir Malachi Bey, committee advisor. Amanda Siegel, committee secretary. Kono Sankofa Bey, committee co-secretary. Once again, this is session 7. The topic for today is the finding of facts, the use of affidavits and notarial processes. Before we get into the main lesson, we're going to let you know where Mike's case is at the time. All right, so we go to the next slide with what we showed in the last class. This was shown in the last class. Mike received a notice of nolle prosequi. Notice of prosequi. So King, you want to take over? We're going to start with this. We have the what the highway patrol had put in their motion. We have Michael's we have the court order. We have the court order. So we're going to show this, and we'll show the court order next, and then we're going to show the motion. All right?
Okay. And when we put together this, right, it was a team effort. And based on my experience, we collaterally attacked the substantive language of the statute. Right? We collaterally, it's making too much noise. When we collaterally attacked the jurisdiction based on the substantive language, the issues surrounding everything that made everything binding, right? So we looked at the language. We put in the following motions to address the language in the statute. We addressed due process issues that was necessary for perfection of jurisdiction or perfection of a claim, right? So we met all those elements. So due to understanding that, we allowed, the court realized that they didn't have jurisdiction to prosecute. So the prosecution put in a notice of nolle prosequi. And that's saying that they don't have enough evidence to prosecute the case, right? So based on what I had addressed for them, right?
Hey, King, put your phone on mute. Put your phone on mute.
That was just my daughter. Hold on 1 second. Let me.
All right. All right. So this is the notice of nolle prosequi. This was reviewed in session 6. which was part 2 of using legal principles to draft motions and pleadings. This was using legal principles to draft motions and pleading. Part 1 is session 4. Using legal principles to draft motions and pleading. Part 2 is session 6, which was the last session. All right, so we wanted to start with this. We ended with this. We're going to start with this. So we're going to let you know where Mike is in the process. All right. Let me know when you're ready, King. Give me the thumbs up. All right, here we go.
So once all of this was put in, right, based on that, now it was just the next phase is once the prosecutor put this in and he determined based on what Mike had countered in his counterclaim, right? Then it was next for them to release the car on an order by the court. So then after he got this from the prosecutor, he had to go to another hearing to get the car released, right? With no fee.
You could put that up, Amanda, the order.
So after he won the case, right? Now he had to go to court and get an order from the judge to take to the agency, the Highway Patrol agency, to get his property back. And as you can see, what he done based on the stuff that this is the stuff that I'm talking about, knowing these principles. See,
Let's have somebody read the order. Somebody read the order, please. Obadiah, you have your glasses. Obadiah, you have your glasses.
Okay. Order on defendant's motion for return of property. This case having come on to be heard before this court.
This cause
having come on to be heard before this court on September 23rd, 2024, on the defendant's motion for return of property, and the court having been duly advised in the premises, it is therefore ordered and adjudged that the Florida Highway Patrol, upon proof of ownership, is to return to the defendant, Michael Long, the 2017 Dodge Charger, which was confiscated on June 11, 2024, at the time of the defendant's arrest. The state of Florida has dismissed all charges related to this arrest. Ordered on Monday, September 23rd, 2024. It's the signature.
This signature, the judge, you have read the bottom underneath the signature. Read that.
It says Hope Patty, court judge. Hope M. Patty.
Well, it doesn't say you don't. All right, doesn't have an M. Hope Patty, county judge. All right. So, King, you have anything else to say about this? We're going to go to King. You're on mute, King. You're muted. You're muted, King.
Yeah. So, based on this, right, knowing these principles, understanding how the process of law works, application of law, operation of law, source of law, all of these different things, right, led me to understand how to address issues when Mike talked to me. So now he had to go through the final stage and getting an order from the court to get his property back. So the prosecutor said, we're not going to prosecute. So the judge said, okay, based on what the prosecutor said, Mr. Long Bay, you're going to get your property back and we're going to return it. And they had no choice but to return it, right? Based on this. Now he has everything he needs to do. If he needs to file a civil suit or anything, if they don't want to return it, he can file all types of, he can file a civil suit. He got to first commence the action. So when you hear the word cause, you look up cause of action. That's what it means. Cause of action. Cause of action. When you see the word cause, it's cause of action. That's what it is.
Thank you for that, King. You want to go to the next one? You want to go to the motion that the state highway filed? All right, here we go. So let's explain this, King. Explain. All right, so that Michael went to. Go ahead.
So on this, so understanding this, right? The highway patrol, they assume through a private act that they can have an attorney, right, file on their behalf to set aside the motion when they don't have no skin in the game at this point, because it was
set aside the
the motion
order. The motion.
Order. I'm
the
sorry.
order. Set aside the order.
Set aside the order, right? Of granting defendant motion for return of property, right? So they believe through their process, right, that they have a right to file this. And if you look at it, they're saying that they had an interest and they weren't notified. But the issue of the matter is the prosecutor works on the behalf of the state, and they are just an agency. They're an agent, right? They can't represent the prosecutorial status that the prosecutor represent on the state's agenda. So they don't have that delegation of authority to act in that capacity, to represent the state in that capacity. Only those who have a law degree, who works in the prosecutor's office or the attorney general's office.
Who's been delegated? It's more so who's been delegated. Well, all right. Let's put whether they have a law degree. All right. Let's I just provide clarity though. If they have a law degree, but don't have the delegated authority. No, so let's say someone who doesn't have a law degree.
Right.
But they're delegated authority though.
Right.
And someone who has a law degree, but they're not delegated authority. Who has the authority? All right. The person with the law degree with no delegated authority, or the person who doesn't have a law degree but have delegated authority. Right. So is it the law degree or is it the delegated authority?
It's delegated.
I don't want to, because it's not because the law degree is not the delegated authority. I mean, they can have that, but I mean, that's good if they have it, they don't have it, but that doesn't, the delegated authority is what weighs. I just wanted to make sure that was hit home, that it's the delegated authority.
Right. So what I want you guys to understand with dealing with this, right? You must understand how law operates. Since they don't have the delegation of authority to act in this capacity, then they can't take and file anything within the court. They're technically are not a party to the suit or the action or the cause of action, even though they were involved in the process because they're law enforcement. But it has a operation of law in which works. It has to work through in order to get to the court. Just like if I will have to file a complaint with the police department. The police department if they decide to do an investigation, they'll do an investigation, and then it would come upon the prosecutor's desk based on the operation of law And then the case will be picked up and pursued by the prosecutor, not by me. This is the same capacity. So the highway patrol is acting out of their delegation of authority. And they're trying not to give Mike his car because they're claiming that they wasn't notified. But that's an issue for them and the prosecutor to take. That's not an issue with them to take up with the court. That's a new issue that they must deal with the prosecutor directly, right? And go through another channel, right? But the prosecutor did not feel it was necessary to do anything or act any further than what he needed to do. So now the highway patrol feel they have the right to do this. This is why the court, Mike hasn't been notified based on anything, because this is now a moot issue and their motion is frivolous.
Let's fill
They
some
have no
questions
legal
now.
standing.
Let's fill some questions, King. All right. Any questions? Any questions? Any comments?
Do we want to read through the,
Yes.
Yeah.
Yes. Well, but I just definitely wanted King to
I do
explain
have
it,
a
and which he
question.
did a great job. Before, all right, do I take let's take the question before we go ahead.
My quick question is this: when we speak of the law degree as compared to delegated authority, now
Yes.
is that the same as when commissioners, magistrates, when they're handling so-called cases that they're only able to sit ministerially? Is that a version of delegated authority, considering that most commissioners, magistrates, they don't have a law degree, nor are they lawyers. They're just people in the community that they put in or vote into that position.
Yeah, but I'm saying, but you're putting the law degree as a matter though, like an element. Like the law degree is irrelevant.
Right. That's what I was asking.
Like,
Like,
it's irrelevant
most people
because
say a
if you're
judge
talking
is supposed to
delegated,
be a lawyer. Like they say a judge is supposed to be a lawyer. All right.
Right.
But you
Right.
have magistrates and the commissioners who are not always lawyers, but they're
So-
delegated.
So could
Go
I
ahead.
answer that for you, brother? Let me make
Yes, sir.
let me make this clear. Okay. If it's a requisite to have a particular law degree to fill the position, then it's a required element to meet that position. But a commissioner doesn't necessarily have to know the law, right? Because he's coming from policy, right? He's dealing with policy, not substantive law or procedural law. He's dealing with internal policies. That is an issue for the court when we talk about operation of law, dealing with substantive procedural law and law, common law, or civil law actions. So he's dealing with more internal issues based on what's going on with that organization, right? So you must understand when we look at application of law, we must look at what is the requisite necessary to hold a seat. There is a particular criteria that's needed to be met. Like if you go to a job, right, they tell you, hey, you got to have this, 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 and this, and this in order to fill this position. These are elements to be able to sit in that position and hold that status or that title of that position. That spills over into law, right? So when we looking at what a judge need to do based on a commissioner or a, let's say, what's a commissioner or another council member, city council, it may not require such elements or degree, right? It's not a requisite to hold that seat. So now we got to look at the job description, and we have to look at what's embedded in order to hold that seat in that position to be able to act in that capacity. Did I make it make sense?
Let me address something. I'm gonna go to not particularly the United States Constitution, but to constitutional principles. So I'm gonna use constitutional principles to make my point. I'm gonna say what I said before about this degree thing. I'm challenging that degree thing based on constitutional principles of any nation, of any nation. All right, let's go to constitutional principles. I'm gonna in a constitution, you have the people of X, France, Germany, Russia, etc. The people of X, unknown. The two people of X, unknown. Once again, the word people, we got it. This is very important. I'm building what I'm saying on this. The word people in a constitution, used in the political sense in a constitution, is the repository of the collective sovereignty of the people vested in a constitution. So, all right, so here we go. We're in Moorish government. Abdullah, you need a law degree to be a judge. So I'm gonna go to the Moorish Constitution. No problem. I'm challenging it. I'm gonna go to the Moorish Constitution. I don't want to see no policy. I don't want to see no act of Moorish Congress. I'll challenge any act of Moorish Congress. I'll challenge any policy. I'll challenge any rule. I'm going to the Moorish Constitution. That supersedes all of that. Now, the people of Morocco, right there. That's powerful right there now. No rule can supersede that of you have to have a law degree to be, a Moorish vizier or, look at the Constitution. I am not advocating for unqualified people. Just hear me out, please, because I'm looking at the rule of law. Based on the rule of law, based on and constitutional governance. No act of Moorish Congress, no rule can supersede that. So does anybody comprehend what I'm saying?
Yes, sir.
Because this I've been delegated authority. Abdullah, you don't have a law degree. I've been duly elected by the people. I ran an election. I won the election. I've been duly elected in Moorish Constitution. The people of Morocco. I've been duly elected by that body. Based on that, I meet the qualifications based on that I've been duly elected by what? The people of Morocco. This concept, my brothers and sisters, I'm gonna say this again, and I might say this 1,000 times before I transition. It's not a lot. It's what? Fundamental principles. I'm giving a fundamental principle. The law degree is irrelevant in any discussion. I rest my case.
I appreciate both of you brothers' answers. Ab, I did get your understanding. And Brother King, I definitely understood you as well. And I appreciate you.
Peace, brother, peace. So when you understand these principles, it make your life easier. This is why when I started teaching, I started showing Abdullah, and he did the research. I mean, this is not a fluke, everyone. We actually took our knowledge based on what I knew, right? Took the knowledge and applied it correctly, right? So Mike listen, you know, just to let everybody know I'm not an attorney, so I can't give legal advice. But what I can do is educate. So based on what I understood, I showed how to deal with cases and collaterally attack jurisdiction and break issues down that most people don't even know how to deal with. Most of us don't understand the judicial system in its own process, let alone the legal system, because the legal system is not the court. The court is just a component of the legal system. And the Constitution determines the what? The legal system that's operating in the political jurisdiction that it has, right? So by operation of law, right, the Constitution is the supreme authority over the three branches of government, right? Just by mere operation. And through the constitutional application in itself, you can raise constitutional questions that can be raised or derived in what they call stare decisis in cases that's already been answered these questions, and that the court or an agency or whatever is being belligerent and not adhering to the principle of law. They're operating outside of that. When you understand these things, right, we're teaching you how to properly understand how to deal with your current cases and understand how to run government.
We're gonna make it very clear, preparing y'all to run Moorish government, because the reason why we will continue to say Moorish government is because it's been thrown out there that, you know, we when King is teaching the principles, it's teaching the legal principles, not the principles, the legal principles. And looking at Michael's case, he's teaching legal principles, preparing the people to run Moorish government. This is transferable. I want to continue to say that. So we're not that this is not the United States is not our government, and we clear on that. But he's teaching legal principles that we can take into and running Moorish government, finding of facts, rule of law, finding of facts, source of law, operation of law, due process, application of law. Those legal principles can be applied in running Moorish government. I'm gonna have to say that 1,000 times, which is fine. I'll say it 1,000 times in different ways. I'll continue to post and reels and TikTok, Instagram, Facebook, whatever I have to do for us to get this concept across. This is preparing us to run Moorish government. He's using Michael's case and other cases in which to do that. And the focus is on legal principles. Can you want to add to that? You want to elaborate on that?
Without knowing the legal principles, right? You will not know law. You cannot run a government. You won't even understand right now the current status you're in without understanding these legal principles. You will be all over the place. That's why this movement has been based in misconceptions, because it's not rooted in the foundation. The legal principles is the DNA, the fabric of this institution, of all legal institutions. The legal principles. So if you don't know the principles, you can never know law. You cannot say you're a scholar. You cannot act scholarly because you don't understand the principles. You don't have the tools to figure out and break down a case. You don't have the tools to know errors, omissions, and defects, right? Errors, omissions, mistakes, and defects. You don't have the tools. So as Abdullah mentioned these things, right? Every government, internationally or domestic, is rooted in this concept. This can go to Russian government, Chinese government, the Ukrainian government, the American government, the Jamaican government. You can go to any world government and it's rooted in this same thing, the foundation. And if you think you're going to build a Moorish government without understanding these things, what's going to happen is you're going to have tyranny, because people are not going to have the proper education, the mindset to be able to run a Moorish government. You can't do it. It's an impossibility. Under the doctrine of impossibility, this is a principle of law. Doctrine of impossibility is an impossibility for anyone that I ever speak to who are not rooted in this concept cannot be a scholar. Cannot be. They don't have the tools necessary. This wasn't a fluke that Mike won his case. This wasn't any like, I didn't prepare for this. I didn't come, we did it live and direct. We went stage by stage through the process. We talked about it, discussed it. Mike went in, performed, and this is the result. No other Moorish group have done this. Took it and went directly into a situation, a live case, right? Took the information and utilized it and made it this sound and came out with this result. Live, where you could go to the video, see every step that was done. This is what understanding and education can do for the movement. Proper concepts, proper legal concepts, proper understanding, right? Not in pseudo law based on someone's own terms and pseudo practices, based on not understanding affidavits and its proper use and what kind of things that they're doing. Not rooted in the evidentiary standards, not rooted in the operation in the rule of law, application, findings of facts, conclusion of law, these things, right? Not just understanding the terms, but understanding how to get your case dismissed based on vagueness, based on construction of the substantive language, based on if it's had too much congressional overreach, where it's is now the congressional overreach is now reaching over into a fundamental right in which it don't have the authority to do. Understanding the different components of what we're doing is very critical. I yield.
This is important. I wanted to King. I wanted to address it. I wanted King to elaborate on it because it's important that we continue to address to teach the legal principles as we are preparing. We continue to prepare people. All right, we have this proposal, Shin Malachi Bey, with his proposal of a plan to facilitate as on our road to recover Moorish lost Moorish sovereignty, to facilitate a Moorish provisional temporary government. And so this is where, we had the Moorish Political Unity Conference on May 18th. And so this Moorish Investigative Research Committee is right in step. And we will have, November or December, we're going to be bringing the various Moorish body politics, together, and we'll have a once a month meeting for 6 months. Well, people are developing. The outreach is growing. The network is growing. Brother McCall contacted me 2 days ago, and the brother in Charleston, South Carolina. He's been following me for years. He contacted me 2 days ago. He has a large following. This brother is a mover and shaker in South Carolina, mover and shaker in North Carolina. He's a mover and shaker in Florida. He has contacts after contacts after contacts. And he reached out to me for the first time 2.5 years ago. I think in April of 2022, 2.5 years ago. And he was modeling, following us, the classes here and there. But then he got very interested in these particular educational sessions of the Moorish Investigative Research Committee. And he reached out to me 6 weeks ago and said, man, y'all doing a great job. Keep doing what you're doing. And like I said, he reached out to me 2 days ago, seeking help with people, dealing with conscious Moors, selling packages upon packages, and you know what I mean? So, package sellers and, $300 and $400 and, not working. So he reached out to me, Abdullah, reach out to me. So, so we kind of connected him with King. And so we got things that we're working with that. So this is growing big time. Our outreach is growing. Brother Quasi's in Boston right now. He had the T-shirt on, the national, the Declaration of the Rights of the Child T-shirt at his event, agriculture event. All right, so this is definitely growing. Sister Sasha and Brother Monty was at the 7th Summit, African Business Summit yesterday. I was on for the first hour via the link that I had registered for a month ago, 3 weeks ago. So they were actually there, and they've met quite a few people, and they will be speaking next year. They will be on the panel speaking. Sasha Ill is one. She was one of the keynote speakers at the Moorish Unity Conference. She's one of the keynote speakers, and she's also on the committee chair of the Moorish the human rights nationality for our children. She's also part of the World Council of Mayors of Save Our Children's Committee. She's part of that too. Dr. Warley. So she has her contacts of range huge. All right. So Sim and I met her and her brother in December of 2022. So the contacts and network are expanding. I said this to Israel this afternoon. I say, Israel, this is since my 31 years, Israel, this is the highest level of consciousness, network, outreach that I've ever been part of in 31 years. So I am, Brother Kono asked me, 2 weeks ago, was it, or last week, early last week. He says, Abdullah, Akona's on too. Akona said, how you doing, Abdullah? How did that? I said, I'm doing great, man. I got off the phone with Brother King, and King and I had a great session as we preparing for these classes. And he said, no, man, how you doing? I said, Akono, I said that I've been involved with this for 31 years. And I get great joy in seeing the likes of the Sister Pecola develop, the Konos, the Kings, the Israels, the Ryseriuses, the Amandas, the Obadiahs. You know what I mean? I get great joy, the Sashas and etc. I get great joy. That you gotta understand. I get great. Kono will tell you, I get great joy. We had this conversation. So right now, today, I was on the phone with Israel today, and and to see his growth and development, to see Sister Pecola's growth. I've known Sister Pecola for 4.5 years. She's been riding with us, ride and die with us 4.5 years. To see her growth and development over the 4.5 years, I get great joy in that. Sister Pecola was at the Moorish convention in Chicago for a week, and she's pushing the agenda. I get great joy in that. I said to Okono, I said, Bob, I sent 6 or 7 of your slides, and she's prepared. What's the title of your book, Okono? And she's been working on this book for 6 months. And I sent 6 of his slides to someone. And I said, man, this brother, man, these slides are awesome, man. So I get great joy in that. All right. So I don't want to belabor the point, but I need to sometimes talk about my experience. We had Ryserius on Moorish Monday, 2 weeks ago. So I yield. When we have a reader. I'm gonna finish up here. I get great joy, and King saying to me, and seeing King's development in international law. And King and I, able to sharpen up each other's swords. I get great joy in that. I did get Shim the hug, King. I did. I said to King 3 days ago, and I was explaining the thing to King, and I was about area of international law, and then just recounting my growth and development over the past 5 years since working closely with Shim. And I said to King, next time I see Shim, I'm gonna give him a hug. I saw Shim yesterday, so I met up with him, and I pressed his hand, and it was a minute later, I was walking ahead of him. I said, and I recalled my saying to King, next time I see Shim, I'm gonna give him a hug. I immediately turned around and gave Shim a hug. I didn't tell Shim why until after. So I immediately turned around and gave Shim a hug. And I explained to him why. All right, so I won't belabor the point. Thank you for your ear. We have a reader.
All right. This was e-filed on November 23rd, 2024 at 4:48 p.m. in the County Court of the 10th Judicial Circuit and for Polk County, Florida. State of Florida, case number.
Obadiah, read the no, hold on. Did you read motion before? Where are you now? I apologize. Where are you?
You reading the caption?
Oh, I apologize. Go ahead, Carl. He's fine. I apologize.
Case number 2024-MM513 versus Michael J. Long. That was the state of Florida.
State of Florida versus Michael J. Long. Yeah.
Motion for rehearing and or to set aside order granting defendant's motion for return of property. Comes now the Florida Highway Patrol Department of Highway Safety and motor vehicles by and through the undersigned attorney and pursuant to Florida Rule of Criminal Procedure 3.192, files this motion for rehearing order and or to set aside order granting defendant's motion for return of property and in support thereof states, 1, the Florida Highway Patrol is the lead investigative agency in 2024-MM-5136. 2, the Florida Highway Patrol maintains all evidence and contraband involved in 2024-MM-5136 at the Troop C Lakeland, Florida Highway Patrol Station. 3, the Florida Highway Patrol did not receive notice of a hearing on defendant's motion for return of property. 4, the notice of hearing filed by the court only noticed the office of the state attorney and the defendant. 5, the Florida Highway Patrol is an essential party to the matter involving the return of any evidence or contraband in this matter. 6, on September 11th, 2024, undersigned counsel informed ASA Curtis Griffin that the Florida Highway Patrol could not return the vehicle in the condition it is in. Undersigned counsel further informed the SAO that the Florida Highway Patrol needed to be noticed for the hearing so that we can put in our objection and concerns on the record. The SAO did not inform us of the hearing on September 23rd, 2024. 7, without notice of the hearing, the Florida Highway Patrol was unable to be heard by the court as to its position on the release of the vehicle. 8, an order entered without notice or opportunity to be heard is a void order. Metro-Dade County versus Curry 632, 2D 667, 668, Florida 3D District 1994. Citing Malone versus Mares, 91, Florida 709, 109, SO 677, 1926, Faulkner versus Amerifirst Federal Savings and Loan, 489, SO 2D 758, Florida 3D DCA 1986. 9, a void order to be attacked at any time. Metro-Dade County versus Curry, 632 SO 2D 667 668, Florida 3D District APP 1994. Citing Shields versus Flynn, 528 SO 2D 967, Florida ED DCA 1988. Faulkner versus Amerifirst Federal Savings and Loan, Supra. 10, as to the merits of the defendant's motion for return of property, if given a chance to be heard by the court, the Florida Highway Patrol would have objected to the release of the vehicle as is. 11, in October 2023, the Florida Highway Patrol decommissioned a black 2017 Dodge Charger, VIN number 2C3DXAT3HH569620, and it was sold at auction to the defendant. The vehicle was solid black. See Exhibit 1. 12, after purchasing the vehicle, the defendant caused the vehicle to be colored in the statutory black and tan paint scheme of the Florida Highway Patrol. See Exhibit 2. 13, under S 321.03 FS It is unlawful unless specifically authorized by the Florida Highway Patrol. A person shall not color or cause to be colored any motor vehicle or motorcycle the same or similar color as the color or colors so prescribed by the Florida Highway Patrol. 14. It is a first-degree misdemeanor to violate statute 321.03 FS. 15. When the vehicle was initially stopped on April 12, 2024, the vehicle has been returned to its original black and tan paint scheme. The wording "State Trooper" could also be seen. 16. While the Florida Highway Patrol disagrees with the decision to null proce the charge against the defendant, it is understood that the vehicle is no longer needed as evidence by the SAO. 17. If the vehicle is to be released by the court, the Florida Highway Patrol requests that it be conditioned to the defendant painting, that it be conditioned on the defendant painting or having the vehicle painted to a color or colors that does not violate statute 321.03 FS prior to release. 18. The Florida Highway Patrol requests that the court vacate its order to return property issued on September 23rd, 2024, and set this for a hearing so the proper parties can be noticed and heard. 19. The alternative, the Florida Highway Patrol requests that the court issue an amended order with the requirement that the defendant must bring vehicle into compliance with Florida statutes prior to its release. Dated this 23rd day of September 2024, respectfully admitted, Rebecca Petit.
Submitted. Respectively submitted.
Rebecca Petit, Deputy Chief Counsel, Florida Bar, number 36351, Department of Highway Safety and Motor Vehicles, 723 Normandy Boulevard, Jacksonville, Florida,
7322.
7322 Normandy Boulevard, Jacksonville, Florida, 32205.
Read the telephone number. Read the telephone number. Read everything you see. Read everything you see.
Okay. Telephone number 904-695-4043. Fax number 904-693-5002. Rebecca Petit at Florida Highway State MV.gov. Wendy Higdon at
Obadiah.
Yes, sir.
Read it as you see it. Read it as you see it.
Got you. Rebecca Petit at FLHSMV.gov. Wendy Higdon at FLHSMV.gov.
The bottom part received.
Okay.
All right, great.
Certificate of service. I hereby certify that a true and correct copy of the foregoing has been filed via electronically using the Florida Court e-portal filing system and furnished by email to the defendant at Michael at SMOCONCRETATEANDCURB.com and Michael at SOLIDSOLUTIONLLE.com and to
LLC.
LLC.com and to the Polk County State's Attorney's Office on this 23rd day of September 2024. Rebecca Petit, Deputy Chief Counsel.
Great job, brother. Great job reading. Thank you.
You're welcome.
And that helps in building confidence too, brother.
Okay. Go through
All right, King.
this. I want y'all to look at this, right? With their motion, Mike had affidavits in support of his motions with the exhibits. They didn't do that. They only got a motion with exhibits. Where's their affidavit in support?
King,
And these photos that they
that King, that
Go ahead,
question,
Mike.
that I didn't even notice that till you just said it. They don't have a sworn affidavit with this motion.
So everything they said is based upon what
Hearsay.
firsthand knowledge? What firsthand knowledge? What firsthand knowledge?
They have none. It's all hearsay. It's fraud. Is it slander, King? Can we get him for slander?
No, it ain't slander, man. Nah.
He's trying to get $1 billion. He's trying to get $1 billion out of this.
Right.
And you know it's true.
Right. So I just want you to pay attention to everything because I showed in the classes how I went about doing the motions. There were motions, affidavits in support with with exhibits that support everything, every position, right? According to the evidentiary standard, right? Because
Numbered, itemized, in the proper legal format, all the way to every motion, every affidavit, every certificate of service, everything was done perfectly. There was nothing that was done improperly, and this is why they had to do what they did. But
look at this. Where's their affidavit of service?
they don't have one.
Where's everything that I did compared to what they did?
Yeah, they're not following their own rules.
Look at what I did and compared to what they did. They just put in the motion and exhibits. I put in motions, we put in motions, affidavits in support with exhibits, right? And we also had affidavits of services, right? Along with that, and they was all incorporated in the affidavit in support. And they was all the other affidavits that other people testified, they were exhibits, right? With the affidavit of service, they were all exhibits. If you see how I laid it out, right? It was very hard to defeat. Now look at what they put in. And they don't even have the jurisdiction to do what they're doing. But look at what they put in. I just want you to look at the difference. I want you to see how thorough I was and this is what they win off of, a lot of y'all, because y'all don't have the proper techniques. That's why y'all need to go back and watch the videos and look at how King was.
That's give them the classes. That's legal. That's session 4 and session 6. Using legal principles to draft motions and pleadings, session 4, and using legal principles to draft motion and pleading, which is part 1, and that's session 4. Session 6, using legal principles to draft motion and pleading, part 2, session 6. On the Moroccan Post Media YouTube page. That's on the Moroccan Post Media YouTube page.
I'm just showing you the comparisons. When you understand how to litigate, right? When you understand what you need to do, when you understand the local rules, the rules of evidence, the rules of procedure, the rules of superintendent, right? The Constitution. These are all moving parts, right? The rules of judicial canon, the rules of professional conduct, right? When you understand all these rules and who govern these rules, guess who govern them rules? Supreme Court. They created those rules. That's under their delegation of authority. So when you don't give them something that bite their teeth in, if you just arguing statute and you're not arguing the constitutionality of the statute, in which I did, which we did, which Mike put together based on the substantive language, right? Which is a fundamental principle that any reasonable person must understand the nature of what they're being charged with under the constitutionality. And then we raise the issue based on several constitutional questions, based on the 4 jurisdictions: common law, equity, admiralty, maritime. We challenging everything that they're trying to put in based on understanding the principles: the rule of law, application of law, source of law, findings of facts, conclusion of law, right? Understanding these principles, family. When you don't understand these things, you can't do this. We didn't have to go back and forth all of that. We put it in. He put it in. Mike put it in Florida, and it came out as exact as I showed him. Hey, this is how I understood based on my knowledge and experience. I got over 15 years of experience of litigating, 15 years of experience on my own, right? How I went about winning cases. Now you got the highway patrol trying to come in and intervene on an action, right? When they should have filed a separate action under another case number as a civil, but they instead came under the same case number, which is under the criminal procedure, even though it's civil in nature, but they still came in trying to move on the case when they should have took a whole separate another action, an individual action on their own, and did a lawsuit on their own. But they came in under the guise through the prosecutor's office, which they cannot do. They don't got the delegation of authority. They could have sued Mike, right? And probably still would have lost, right? Because Mike already won, right? They could have tried to sway the court because in a criminal case, you got to have the beyond the evidence standard, right? You got to have the beyond, what is it called? Reasonable doubt.
Reasonable
right?
doubt. Yeah.
Reasonable doubt, right? You got to have reasonable doubt standard, evidentiary standard. Then you got preponderance of evidence. So we have to look at that because you only have this tip the scale by 51%. But the issue was, they said cause. Michael either painted the car or caused it to be painted. Michael never did neither one. The paint came off. They put a poor paint job on there. Now they're trying to make him liable to repaint it. No, y'all should have did a good job from the beginning, and this would have never happened. You're not gonna put this poor paint job on there and then tell me I have to repaint the car. No, you the ones who had the duty to make sure that when y'all decommissioned the car, that it was totally, truly decommissioned. All the decals and everything couldn't be seen based on your efforts, your due diligence. It wasn't, Mike bought the car in that condition. He didn't cause the condition. Mike, you got anything to say, my brother?
No, I mean, you're doing a great job. I mean, it speaks for itself, really, to be honest with you. I mean, That's why the paperwork speaks for itself. So the Mike doesn't even have to say anything. You know, anything I have to say would just be fluff.
All right, so we're gonna go right to the second. We're gonna go to the main.
I wanna-
Let's, we can go, you want
I
to go
want
to the main
say one
session
thing
lesson?
before Mike,
Go ahead.
before we enter that.
All
Mike,
right.
Mike, you still there? Mike,
Yeah, I'm here.
how did I go in on that prosecutor?
Oh, when we was on the phone.
Yeah.
Oh yeah, address that.
Hey, yeah, it was very straightforward and to the point, as if he was a public servant, because he is a public servant. And basically directed him, told him, you know, what we wanted him to do, and that you know, that they would need to call down there and figure out, you know, to release the car. Yeah.
Just wanted to let y'all know, right?
We did release it, correct?
What did you say, Amanda?
They did release it?
No.
Not
No.
yet. But I tore into the prosecutor. I really got into him where he was trying to give a lot of BS, and I had to chew him up and really let him know. And then he was like, "Hold on, I got to talk to someone," and he came back with some answers. That's all I wanted to address, Mike.
All right, so we'll go right into the main lesson.
Okay.
All right, Amanda, we can go right into the main lesson.
You gotta go back up. Oh, you read that already, Abdullah?
Yeah.
Okay.
Yes, I read that.
Let us know when we get questions, Abdullah.
Before we get into, you have questions? Before we move into this main session, any questions?
Yeah.
Comments?
What
All
you were
right.
saying, this brother Kenneth, you know, could you elaborate? Because it's like, again, I like what you said. We could transfer this to Moorish law. Elaborate on that for us, please.
All right. I want you to look up. All right. We talk about legal principles. All right. So we have. Let me just break this down. And as we move towards, as we are on the road to recovery of lost Moorish sovereignty. Question: well, what legal system are we going to have? Civil legal system, common law legal system, religious law legal system, a mixture of common law, civil law, or customary law? That's one question. Second question: what political system? They're not the same. Legal system and political system are not the same. So we're talking about political system. We're talking about a republican form of government, a constitutional monarch, a absolute monarch, a socialist republic. Those are political systems. You have legal systems, you have political systems. So when drafting a constitution, in order to you want to what? You want to draft in a constitution the people what's called fundamental rights, which is a legal system, a legal principle. The rule of law, you're looking at the accessibility, accountability, open government, people being the government, limitation of government being bound to the people. That falls under the rule of law. You have due process. And this will be drafted in a constitution. But if you don't know this, you're not going to draft in a constitution because you don't know it, and therefore you don't have a constitution. I don't care. All right, you can call it a constitution. It's not a constitution. You can call it that. It's not a constitution. All right? You have the rule of law and you'll see me post, done reels, and I've done posts, for the past couple of weeks. You have the rule of law and constitutional governance. The legal principles are the underpinning, the fabric, the DNA of a legal system. Once again, we say legal system, that's not a court system. All right. You've heard all your life. You've been indoctrinated improperly. You've been indoctrinated improperly. Court is not a legal system. That's not a legal system. They'll say, well, the legal system, and talk about court, that's not a legal system. Court is a component of a legal system. Once again, legal systems, common law legal system, civil law legal system, religious law legal system, customary law legal system, a mixture of common law and civil law. Those are legal systems. A court is a component of a country's or nation state's legal system. It is not the legal system. So we have to use being indoctrinated and being educated, groomed into the proper language. Because the mass of the people, that's millions. That's both conscious Moors, unconscious Moors, and Europeans. When they use the term legal system, they only refer to court. That is incorrect. Court is not a legal system. That's a component of a legal system. All right, so did I answer your question?
Oh, yes, thanks, brother.
All right.
Real quick, could you break down that political system one more time?
All right. You have legal systems, you have political systems. Examples of political systems would be a republic form of government, a socialist republic, a socialist system, a constitutional monarch, an absolute monarch. Those are examples of political systems. But now we're talking political science. And we're talking legal system, we're talking jurisprudence. So this is a mixture of jurisprudence, which is the philosophy of law, political science, political philosophy. So we're blending, we have to actually blended all of them, all of those disciplines. Because we got to come from them. We got to come from jurisprudence. We got to come from political science. We got to come from philosophy of political philosophy. All right. And you can Google that, Kara, or anybody. You can Google political systems. Just Google political systems, and you'll have, Mary come up.
Appreciate that.
You Google legal systems.
Brother,
you'll see those 5: common law, civil law, a blending of mixture of common and civil law. You have religious law and you have customary law. Those are the 5.
I got a question, Abdul.
Yes, go ahead.
Pose a question to the group.
Mm-hmm.
What is the current legal system that the United States is in currently? Do anybody know?
This brother Kenneth, the United States is running a criminal, civil, mixed legal systems. It's not ecclesiastical. It's not ecclesiastical. I don't see that, but I do see criminal, civil, and mixed. Yeah, criminal, civil, and mixed.
All right, Obadiah, look up legal systems. This is right, but look up legal systems. So you could. I don't want you to say Abdullah said anything.
It's a democracy.
No,
I don't want you. No,
I got everything written down. But
no. Obadiah, look up legal systems.
Right, criminal is not one of them.
Thank you.
So you just
That's why I want you to look for it that becomes your own, not Abdullah. It's not based on Abdullah saying anything. So don't say Abdullah said anything. Look it up. Look up the legal system. Look up legal systems. Look up political systems.
I just like to say that touches as a the whole situation that they showed from the fact that when we get off bases, if we was in a courtroom and we go off base, that allows them to go off base. But this case showed evidence of remaining on the rule of law, which would make them have to play up or make them have to up their game because most of them don't remain on the rule of law anyway. So
Good point.
But let me say this. Listen, when I walk in the courtroom, based on what I know, it's a difference. It's just a difference. I don't have to go back and forth with the judge. I don't have to do all of that. I already know my position. I already know when he start doing certain things, I already know how to do my job. I already know when he start doing or prosecute, I already know what to do. I don't have to question myself. I already know what I need to do. And I handle business while I'm in there. I don't get nervous. I don't get all discombobulated. I know what to do. I know how to handle the case. I know what to do. I done seen it so much, it's routine to me. When you root yourself in the legal principles, you don't go in there and do all of that. You know how to handle the job. That's just like anybody who's a master at what they do, a master carpenter, a master plumber. They go in there, do the job. A regular plumber might come in and can't do it, but the master plumber come in and he's a master. He can do it all. I made sure I mastered this science, so when I start seeing things that I know is out of character of the court, I deal with it appropriately. I don't misappropriate the law. I deal with it appropriately because now I understand what I need to do. I hope that makes sense to y'all. This is why I'm teaching y'all this, so you guys can see. Now we finna get into affidavits and how affidavits work. I yield.
And we have a different reader. A different reader. Sister Bacola, you want to read?
She here. I can read. Fact-finding tools. The use of affidavits and notary processes to strengthen your case. In both civil and criminal cases, affidavits and notary processes can serve as powerful fact-finding tools to gather and present evidence that can sway the court in your favor. In civil matters, your objective is to win by proving your claims through a preponderance of the evidence, meaning you must convince the jury that it is more likely than not, 51%, that your claims are valid. In criminal cases, the burden of proof is much higher, requiring that the jury be convinced beyond a reasonable doubt. If the jury is evenly split, 50-50, or cannot reach a unanimous decision, the result is a hung jury, which can lead to a mistrial or a not guilty verdict due to insufficient evidence. Understanding affidavits. An affidavit is a sworn statement made under oath, often used to present facts and evidence in court. Affidavits can be a critical component in both civil and criminal cases, as they provide a formal way to introduce factual information. There are various types of affidavits, each with a specific function depending on the legal context. Affidavit 1, affidavit of fact, a basic statement of facts within the affiant's personal knowledge. 2, affidavit in support, used to support a claim, petition, or motion by providing evidence or context as to why it should be granted. Affidavit in lieu, 3, submitted in place of other evidence when original documents are unavailable or inaccessible. 4, affidavit of service, used to prove that legal documents have been properly delivered to a party. Example, affidavit in lieu of a birth certificate. In cases where an official birth certificate is unavailable, an affidavit in lieu of the birth certificate may be used. The affiant, having firsthand knowledge of the birth and being of sound mind, attest to the details surrounding the birth in the absence of official documentation.
Amanda, that's pronounced affiant.
Thank you.
Mhm.
Proper use of affidavits. For an affidavit to be effective, it must be factual, clearly stated, and based on personal knowledge. It is essential that the affidavit be notarized, which confirms that the affiant has sworn under oath to the truthfulness of the content. There are hundreds of styles of affidavits, and learning how to use them as a resource for evidence can be a critical strategy in any legal matter. A common misconception, particularly among groups such as the Moors, is the belief that simply being a Moor or using affidavits act as a get-out-of-jail-free card. However, affidavits are not a magical solution to bypass legal obligations. Through this process, you will learn the true function and significance of affidavits. While they are invaluable tools for presenting facts and evidence, they are not an automatic dismissal of legal responsibilities. The role of notary processes in building credibility. Notary processes enhance the credibility of your documents, verifying their authenticity and confirming the identity of the involved parties. A notary acts as an impartial witness and a public official, ensuring that legal formality.
To stop there, Amanda, let's go back to affidavits before we get into notary. King, let's have discussions and questions. Let's fill, King, you there? Further discussions and questions on this, on affidavits before we move to
So
notary processes.
we're going to talk about affidavits in various states, right? Affidavits, I didn't state there's other things that you could do associated. Affidavits can come in the form of a contract, right? Affidavits can come in the form of exhibits. Affidavit can be attachments to a contract or other things, right? So there are many, I don't want you to get stuck on an affidavit in a sense, because there are a lot of styles of different affidavits. Affidavit of marriage, affidavit for financial, affidavit of financial, affidavit of it's just so many affidavits, right? So a lot of Moors get caught up in the affidavit of truth or affidavit of fact, but it has to be associated with something, right? When we looking at cause of an action, right? A lot of times I like to place affidavits in conjunction with contracts. And these affidavits is styled in accordance to whatever contract that I'm utilizing to support and strengthen my position by both parties acknowledging and signing the contract, and an affidavit is being used, or attestation or protest is being used by the notary within that, or she's acknowledging the parties and attesting to certain things. So according to this contractual obligation, as it validates the two parties and their position, right? And their rights in contract. So a lot of us don't even understand affidavits in entirety. They just assume that there's affidavits of truth, affidavits of facts, as those are the ultimate affidavits, right? When there's various, I'm talking about literally hundreds of affidavits, right? Also, we're going to talk about authentication. So a lot of people, I didn't add that in here. I could have added that. So what a lot of people think that about authentication, they think like, oh man, I got to get this I got to get my birth certificate authenticated. Who authenticates things, right? So a form of authentication, if me and Abdullah said that we signed this contract and that's our signature on the contract, that's a form of authentication. We just authenticated that we read and signed the contract. So you can have an identification document in there in the form of an affidavit that's connected to a contract as an exhibit, right? That this party had read, showing that they read the contract, read it, placed their signature, thumbprint, or whatever, or even a picture to go with it that day, that we took a picture of this person to attach as an exhibit, what he had on in this before signing this contract. There's so many things that you could do. It's so many things. I'm just
Well,
touching the surface.
Well,
Right.
just as you go, just think of it, and we'll revisit this, and so we'll have this, and we'll put this, we'll list some more things. But as you can remember, this is good. You're doing a great job.
So,
Go ahead, King. Go ahead.
so I just wanted to elaborate. I just see so many affidavits of truths and so many affidavits of facts, but there's so many other styles of affidavits that's not being used. It's so many it's people don't even understand how to properly use an affidavit and how it can be authenticated, right? And how to authenticate signatures, right? And contracts based on an affidavit that parties have read it, and that this document can be used to authenticate the signatures of both parties. You see what I'm saying? In the form of an affidavit. And then you can have a third party testify and testation or a notary stating that these two parties signed. Then you can add another form of authentication to the process, because you're authenticating that it's a true notary recognized by the state, and that her notary seal and her title is that she was operating in her capacity at the time, that the state authenticating that it was a real notary at the time of the signing of the document, and that her license as notary was valid at the time of creating such document, where nobody can challenge that affidavit. So I can go into a plethora of situations how to properly use affidavits. But I'm gonna keep it a little more simple, right? Is something that you want to add, Abdullah?
If you can add a few more of your plethora.
Right. So I'm just talking about affidavits and associated with contracts, trusts, creations of corporations. Man, it's so many things that I see that is not a part of our development in the use of affidavits. It's so many areas that we are weak at when it comes to affidavits and their proper use. I just see Moorish doing affidavits of truth, affidavits of facts, affidavits of truth, affidavits of facts, as is that the say all be all, and that the affidavit cannot be challenged and it can't be challenged and not be overthrown. Just because you put in an affidavit don't mean the other party affidavit is not doesn't have validity or cannot overpower your affidavit. Because of your affidavit inconsistency, the things that you have in the affidavit don't align with your motion or anything else, right? Especially if you don't have firsthand knowledge. So it's so many things that you have to understand about affidavits that I see that the movement don't have, because they're stuck in misconceptions about affidavits. All I got to do is put in the affidavit of truth and it'll defeat everything. All I got to do is put in an affidavit of fact, and I'm going to get the case dismissed. And the court looking at that as frivolous.
I want you to spend more. The reason I'm saying to go into your bag of plethora tricks, because this is as you said so eloquently, that this is a area that needs time, needs education. We put this because Conscious Moore has been groomed into the misconceptions of affidavits. We want to fill some questions, y'all. If y'all got questions, comments, or criticism regarding affidavits, comments you heard about affidavits, questions you want to ask, we don't want to rush through this. We do not want to rush through this. Believe me, this is a major area that we have to grow into, even into as we prepare on, as we on the road to Moorish, recovery of lost Moorish sovereignty. This knowledge is be what? Transferable to what? And running Moorish government. Transferable into running Moorish government. So we always have Moorish government in mind. We're on the road. You're not going to hear Abdullah Bey say, you're not going to hear King El Bey say, you're not going to hear Sister Bakola Lee Kusar El say, you're not going to hear Kono Sankofa Bey say, you're not going to hear Quasi Il say, you're not going to hear Terrence Bey say, they're not going to say, we've recovered lost Moorish sovereignty until we've done it. You know what I mean? Until we've done it. We've recovered lost Moorish sovereignty. We got a state. We got a Moorish state. You know what I mean? You know, we re-entered the international community as an old and written state. You're not going to hear us say that. When you do that, all right, what are we trying to do? As I was on the phone with Israel this afternoon, and I said, Israel, when we want to get the attention of people throughout the world. Like you have that remember those radios with the dials? You know what I mean? You got that. I mean, you got the station you wanted. You got the station. You know, it's either playing a song, or you got a sports talk station, or radio talk station. You know what I mean? I mean, you're on the right frequency. So when you speak with intelligence, speak in the proper legal concepts and jurisprudence and legal principles, they'll recognize your tone. When you got misconceptions and chaotic and all over the place, somebody who's a consul general, a vice consul, a consul, an ambassador. You know, as I said, Sister Sasha and the brother Monty, they were at the free, the business summit, the African Business Summit, the 7th one. All right, and they're growing in proper concepts. So as you interface with different ambassadors and so forth, they hear your tone. But when you start speaking misconceptions, they're going to ignore you. You're not going to get their attention. This is how you get their attention. We must be in the right tone, the right frequency. This Moorish movement's been off tone. You know what I mean? They're like that, off tone. I can't sing. Well, you can't sing, Abdullah. Well, that's this Moorish movement. You're off tone, Abdullah. Well, that's this Moorish movement. So I'm off tone. Well, so is this Moorish movement. Shem Malachi Bey is a major factor of putting this Moorish movement on the right tone. Any questions?
Comments? Got his hand up.
Why serious?
Yeah. My quick question is this. Moors have been led to believe two things. One, Moors don't utilize motions. Moors utilize affidavits. That's one. And two, Moors don't petition. Can you give me the truth or falseness of those statements?
All right, that's in along with motions. Serious. That I understand where you're coming from. I mean, let me just complete it. So when you say Moors don't petition, what Viserious means is that it's been said that a motion is a petition to the court or a question for the court to answer, and that the judge, this has been taught, that the judge has discretion. The judge can use discretion to dismiss your motion. But when you put in an affidavit, I know it well. When you put in an affidavit, the judge cannot dismiss, does not have discretionary power to dismiss your affidavit. You put in a motion, you're asking, it's like asking a court to answer a question. It's like begging the court when you're putting a motion. The judge has discretion to dismiss your motion. That's what I'm very serious. That's, just wanted to complete it. I know it well.
So the misconception about affidavits and all of that, because a lot of people say, if I put in a motion, I gave the court jurisdiction, right? So we have to understand, that's why I say you got to know these legal principles and political legitimacy and legal understanding. When you don't understand these principles, then you all over the place. You don't know how to confer to the court. You don't know how to confer. So you say anything, right, to make it make sense. And that's one of the problems. So let me explain what an affidavit is. It's a part of an evidentiary standard, right? It's a tool.
All right, so put that down. Affidavit. Go ahead, King.
So an affidavit, right, is a part of the evidentiary standard of process. Evidentiary standard. It's a way to get credible evidence. It's a way to have more credible evidence be presented, or have evidence, right, based on certain things. Someone testifying, it could be a form of testamentary evidence, right? Someone testifying in the form of affidavit. It also could be associated with a contract. For example, you can have a contract and it says that the parties sign this affidavit, this undersigned affidavit, that they agree to everything, right? And that this is a part of the contract, and that they had read it and waive all rights in order to finish or complete the contract, or whatever it is. And then they sign that, and it's notarized. It becomes an affidavit, and it can be an attachment to a contract or an exhibit to a contract or anything else. So you can submit that enforcing, right, your contract, giving your contract more validity, that the parties have read the contract and did everything, and that they signed this portion of this agreement of a contract that now can be used as an exhibit. It's a fact-finding tool. So y'all got to understand that filing an affidavit, the court will not answer. It doesn't cause the court to move. It doesn't move or bring action to the court. The court will not entertain an affidavit unless it's in the form of a motion. Now, you could do a motion in the form of an affidavit, but it has to be a motion incorporated in the affidavit. But just filing an affidavit doesn't make the court move. It doesn't allow the court to do anything. You can try to challenge the jurisdiction with an affidavit, but it's not going to have, because you don't necessarily, right, meet the application of law in which that make the court to act. You're not making the court act with an affidavit. You're trying to get the court to move or act on your behalf. That's affidavit is not what you do to make a court act. It's a fact-finding tool. It can support evidence. It can be used as exhibits or other things, but it's not a motion to get the court act.
Come on, y'all. We got questions, y'all. Y'all got questions. Y'all got questions, comments, and things y'all, statements y'all heard over the years. Let's bring it on. Let's bring it on.
I've been through it all, family. I ain't heard. It ain't nothing. It ain't too much I haven't heard.
Any other questions, comments, of what you've heard? What have you heard about affidavits?
I put in the affidavit of nationality. And I would say, where's your Moorish government that recognized your affidavit of nationality?
All right, so so you're putting an affidavit of nationality to a foreign government. So I'm a French citizen. I'm French. I put in an affidavit of nationality to the Japanese government. So I like to do it like that. Let's so that we can really hit it home. But this is what the problem is, King. Because conscious Moors have taught, and I was one of them. I'll raise my hand. I taught this misconception to thousands of conscious Moors and for 25 years. So I'm part of the blame. I was part of the problem. So I got to make amends for it. That this is the Moorish government. The United States is actually the Moorish government. That we, the people of the United States, that's the Moors. 35 Moors were at the Constitutional Convention. This is the Moorish government. This is the Moorish Constitution. So a lot of it's there. That's it's rooted in that. The state is rooted in that. That this is our government. You know what I mean? So the example that I'm giving, so those conscious Moors who still hold on to the misconception that the United States, that government is actually the Moorish government, they're not going to get the example. Well, I'm a French, and I put in an affidavit of nationality to the Japanese government. They're not going to get that because they really think that the United States is the Moorish government, and the United States Constitution is actually the Moorish Constitution, and that the Moors are the founding fathers of this government, and 35 Moors were at the Constitutional Convention. I taught that for 25 years to thousands of people. And that's still just hearing conscious Moors still teach that. I'm like, wow. And now I can break it apart I'm like listening to Abdullah Bey, like I'm listening to the old Abdullah Bey. So if I hear a conscious Moor teach that, it's like I'm listening to myself where I was. It's like a reminder of where I was for 25 years. And I know they got it from me, and they got it from other people, and a lot of people listen to me over the years. So but if you listen to me from 2018, from 2019 to the day, you're not going to hear me say that. If you go back 2016 or 15 or 13 or 2010, you could pull up my old tapes. I've said that. That's why I have to admit. People can pull up my old tapes and say, you said this, Abdullah. Well, I know I said that. But now I can prove that what I said for a 25-year period through the finding of facts is not so. I can prove it. Any other questions? Comments? And keep in mind, no conscious Moor can prove. I'll challenge any conscious Moor. No conscious Moor can prove that Moors are the founders of the United States. No conscious Moor can prove. They will say, I say, prove. No conscious Moors can prove with finding of facts. So what they'll do is they'll say it, and they'll get boisterous, and they'll get loud, and when you present finding of facts, they'll talk over your finding of facts. When but no conscious Moor can show you finding of facts to support the claim that Moors are the founders of the United States. They can't. They'll just talk loud and talk loud and talk loud and be boisterous and just say it 1,000 times and, present the fact. And they'll just repeat the same thing and they'll say it again. They'll repeat the claim and say, well, present. They'll present the claim as if it's facts. Like they'll repeat the claim 1,000 times as if it's facts. That's what they'll do because they don't have the facts. What they have is they've listened to Abdullah Bey. They listened to Abdullah Bey. They've listened to others, and I won't only say my name. So they've listened to Abdullah Bey in 2005, 2010, 2005, 2010, 2000. They listened to me. They listened to other conscious Moors, and they just repeated me. That's all. So now they don't need to repeat me anymore because I show finding of facts that we are not that. That's all. So that's where it is, King. It's in that. You know, I know because I was there. That's where it is.
So I want you to understand another word for they'll make a claim is cause of action. It's a cause. You made a claim. Now you got to prove your claim. And there's things you must know in order to prove a claim. And you must know these principles, right? And including to what the teachings you get to now perfect your claim and be able to stand on it so you can have standing. Everybody don't have this abundance of information. And I'm giving away to y'all for free to allow y'all to come in and help build Moorish government. That's what me and Abdullah is doing. We're giving a lot of information out. Like the stuff that I'm giving you, you're not gonna find on no YouTube videos other than this. I have other videos on my Moorish Union of Sovereign Tribes video, and I go into some stuff. But I be trying to hold back a little bit, but I still give out a lot of good information, a lot of free game. And people ask me, how King, wow, and I'm showing and proving y'all, right? We breaking it down. All the stuff that you can do, you can fact check. Right? Anything that I'm saying, you can go fact check. All this stuff in this, talking about affidavits, you can go fact. All this stuff in this document, you can fact check. You can fact check. So we can continue. We was on the next phase.
Next, you want to go. So you ready to go into the rule of notary processes and building credibility. All right. We have another reader. Serious.
The role of notary process in building credibility. Notary processes enhance the credibility of documents, verifying their authenticity and confirming the identity of the involved parties. A notary acts as an impartial witness and public official, ensuring that legal formalities are followed properly. The following are commonly used notarial acts that can serve as fact-finding tools and help validate evidence. Number one, notary protest. A formal declaration made by a notary regarding the dishonor of a financial instrument, such as a bill or check. Number two, notary attestation. The notary attests to the accuracy or authenticity of a document or fact, often used for religious name changes or attesting to the facts in an affidavit. Number three, notary acknowledgement. The notary verifies that the person signing a document does so voluntarily and confirms their identity. Number four, notary presentment. The notary presents documents to another party on your behalf, adding a level of official validation. The notary can also monitor document exchanges between parties, helping to determine if someone is in default. Utilizing the notary and affidavit together. Combining with notary process strengthens the legitimacy of your evidence. The involvement of a notary as a state-appointed official adds an extra layer of credibility to your affidavits and any supporting documents. For example, notarial presentment can be especially useful in contract disputes, as the notary witnesses both the delivery and receipt of documents, ensuring transparency throughout the process. Establishing the rightness of your claim. Notarial acts can also be used strategically to establish the rightness of your claim. For instance, you can submit notarized inquiries such as a Freedom of Information Act request, which helps establish facts that meet the court's evidentiary standards. These notarized inquiries reinforce your position by ensuring that the information presented is verified and credible. Specific notarial acts as legal protests. Certain notarial acts can be employed as legal protests, particularly in situations involving unlawful actions or contract disputes. For example, a notarial protest may be used to contest an unlawful claim or term in a contract, such as the use of the word payment when it is not clearly defined in the agreement. Sending a notarial protest enables you to dispute a bill, amount owed, or other contract terms. In mortgage disputes, for example, the contract itself may be used as an exhibit, demonstrating that crucial terms like payment are undefined, requiring the court to consider the source of law in defining these terms. Conclusion. Affidavits and notary processes are crucial fact-finding tools that offer credibility. Let me read that again. Affidavits and notary processes are crucial fact-finding tools that offer credibility, authenticity, and transparency in both civil and criminal cases. Understanding how to properly use these tools and aligning them with legal standards, such as due process and evidentiary rules, can significantly strengthen your case. When applied strategically, notarial acts and affidavits serve to bolster your claims and challenge opposing parties, ensuring that your case is backed by credible and official documentation.
I hope everyone, was that too much? Was that simple, right? Serious to understand?
Yes, sir.
So putting this stuff together for the people, right? Understand, like when I talk about notarial acts, right? You got notarial protest, notarial attestation, acknowledge, right? And what is it? Protest, acknowledgement, presentment, and attestation. Right?
Attestation, yes.
So when you look at these, right? These, so you got different styles of affidavits, right? You could just have an affidavit acknowledged, boom, right? You can have an unsworn affidavit, right? Under what is it? Was it 17? Was it 1728 USC United States Code unsworn declaration? Right? You can use that as a way. You can, so it's all types of things that you can do, right? And have everything authenticated, sworn. It's so many things you can do. But when you understand notarial acts align with affidavits, right? And have the notary with her act as an official, state official, that makes your case even stronger, right? And when you understand how to utilize these tools and you know how to navigate and be creative with using these tools, you just put yourself in a better position. Like, for example, a lot of people don't understand about mortgages and how to utilize a notary protest. When you're going through your contract, you got to read over it. Let's say you find some errors, defects, and omissions, and you protest against that. It's a way that you have to do it. You have to allow the notary to present everything and protest against what's going on at the transaction. That now you let them know that you found some defects and omissions in the contract that you need to correct. And fail to correct these things and accept these things, right? That you address these things in the contract and you show the contract, the errors, the particular error in the contract and what page and what line it exists, right? Based on what you're trying to do, you can protest everything, right? Hold on, let me charge my. I thought this was gonna be charged. No.
This,
I gotta charge my laptop. It's
All
just
right, we have any questions or comments?
So basically, the notary can be used to give the affidavits more credibility.
Yes, if
So
you
both
look,
of them are
okay,
fact tools to validate your facts.
absolutely, absolutely. You looking at notary protest, notary attestation, notary acknowledgement, notary presentment. Absolutely, it gives it more credibility. You know, we look notary presentment where the notary will act on your behalf. So the notary will send meaning the notary will receive documents. Like, you know, it won't be mailed to you, it'll be mailed to the notary. The notary will send documents. You know, you're talking about notary presentment. So there's different processes as well.
so the notary would send out
Okay.
everything, and
Mhm.
the notary would document everything that went out and everything that went in. So there'd be like a transaction statement that the notary will record as to verify that she did perform those things on your behalf and that the other party was in dishonor because they failed to resolve the issues when it was necessarily within the contract, that the bounds of the contract, and that they failed to meet an obligation in the contract, right? So now you can have legitimacy to win your case based on they had an obligation and that they failed to deal with that. So it's just so many different things. I could go over a whole lot. Like I said, I've been doing this for a long time. This is nothing new, right? So we're talking about different areas of law that I'm just, I'm good at, based on understanding how to utilize these tools and these techniques and having a mind to use these things, right? I've been doing it so long, so I got creative with some of the stuff, but it's still within the scope of what is I can use it for. I'm not going outside of the scope, right? I'm staying within the substantive language. So when we talk about applications of law, right, when performing a particular act, you guys got to understand this, right? Unless you're dealing in contract law, some private law, but dealing with private rights, especially institutions, right? They're statutory in nature. So let's say you create an LLC, you still got to follow the rules, right? But of the statute, as because it's a statutory creature, it's a creature of the state. So you still have to be within the state jurisdiction, but you got to understand that thing has the right, also have a right to contract in such a way that benefit the principal, right? And you got to learn how to utilize these different variations of institutions, right? That's why it's very important that we understand how notaries play a part. If you look at most banks, courthouses, even a lot of churches or some places, there always sit a notary. Notaries, if you look at a lot of different, like I said, banks, uh, a lot of different places. I think even hospitals, they have a notary. Courthouses, they have a notary, right? Always in a bank, you have a notary, right? There, a notary sits somewhere in a lot of various institutions. So that's something that you need to be considering too. Anybody got any questions? No questions? No questions. Come
Guess
on,
you
let's
did
have
it.
a good question.
Guess you did a thorough job.
There has to be some questions, Abdul.
Um, I'm trying to pry it out of them.
I don't know.
Do we have another? Are we completed here, Amanda? Is there another section? Another page?
No, we can.
I think that's it.
That's it. We did this in an hour? Remember, we spent an hour on, well,
It's
Mike.
been a couple of hours.
No, I'm saying we did this section in about
Oh.
less than an hour, but we spent like over an hour on Mike's joint.
Right.
Yeah, which was neat anyway. But all right, wow, we don't want to rush through this, but being that there aren't any questions,
I'm trying to, it got to be some
I
question.
know we really see it. Let's try to find out for another minute. Any questions, comments? All right, all right, any other examples you can think of, King?
There's so many examples I could think of. Let's say, for example, right? You want to use a freedom of information request. And let's say, let's talk about taxes, right? You could use an affidavit in lieu of a W-4, an affidavit in lieu of any other contract, especially when you don't have the original or if you don't want to use their particular form, as long as you meet the criteria of that. A lot of times they accept that affidavit in lieu of a particular form. If you want to send it into the Internal Revenue or whatever, or you do an affidavit in lieu of the birth certificate, or you do an affidavit of live birth, right? And then it's so many things you could do. It's just a thousand things I could think about that I utilize, right?
What about the Freedom of Information Act? What about the Freedom of Information? You did mention that. So that's
okay. A lot of times I will use in conjunction the notary protest when doing a freedom of information request, because a lot of times they will not answer back. But when a notary do it and present to gather certain information that I'm trying to use in criminal cases and other things, because as a third party, for example, I talk about various things that I do. I utilize it. Say you might have a case, I might come in as another party, and like let's say police records, because a lot of times the police don't want to, like if you in a case, they say, well, you have to go through the prosecutor to get the discovery. So as a third party, right, I can use a freedom of information request to, or open information request to obtain that record, because it's public records, and get that information, right? So it's so many things like, or let's say you get a traffic ticket and before you go to court, they say you got 30 days to, pay, or you got to go to court or whatever. You can use a freedom of information request to get information and gather information prior to going to court. So, like I said, there's so many things that I could think about with notarial protests, notarial protest, a notarial attestation, acknowledgement, and a notarial presentment. But these are strategies, and you got to know how to incorporate in what you're trying to do when you're doing business. Any type of, even if it's non-commercial, these are tools that you can use to help safeguard what you're trying to do. Come on, man. Ask me some questions, family. I'm talking Chinese.
Can you hear me?
yeah, go ahead, Kara.
Yeah, question on the affidavits. Affidavits are presented by way of firsthand knowledge.
Right. Correct.
Okay. When you're dealing with institutions like child social services, a lot of times the people you're dealing with is not moving from firsthand knowledge. Is there specific affidavits that you go in with a situation like that?
You can use an affidavit, right? The affidavit to challenge. So, like for example, They put it like in child support. They do this all the time. They have a affidavit acknowledging that you signed a birth certificate. They don't have no firsthand knowledge, so you can use an affidavit, right, in support of your motion to challenge the affidavit of protesting against the affidavit of acknowledgement by the hearing officer or whoever putting in that affidavit that you're challenging that and you're protesting against that. You can use the affidavit to protest, right? Affidavit of protest in support of said motion or whatever to diffuse that based on some facts and then present some exhibits, and then you can put a line of questioning to them, right? Under interrogatories and admissions, getting that person to address that they never seen or know your signature, or they are expert in hand signatures or whatever. So I do so many things. I'm telling you, like, I think about court stuff, I get excited because I know I could do so many different things with the court. Like I don't look at the court as a challenge for me anymore, right? I just entertain myself with it because I'm so good at it.
Right, right. What I excuse me, what I'm noticing is like right now I'm looking at a child services situation where a child has been taken, but the attorney is not dealing with any of the principles that we're going over here from that aspect, even from the aspect where you got
You
the
have
case.
to be dealing with an application of law. Has to be dealing with an application of law. What is the action that they taken? And did they meet the elements of that action? That's the principle. They have to meet it. They have to be understanding application of law. You got to understand, what is the application that's being used? What is the substantive language? Did they meet the elements of that substantive language in order to act, right? Under their delegated power. And did you give them such delegated power? Right? Because a lot of times they be acting in capacities that with private and interfering with private rights outside their scope. And then you could put together the constitutional question: could an institution, right, rights that is safeguarded, right, by the Constitution, by the by the 5th and 14th Amendment of due process, that the party did not sign a contract in which the party could show and prove that they can act on that party's behalf in such capacity to intervene with the rights of this, especially if it's dealing with religious rights. So it's so many things that I know how to do it just off the top of my head to deal with any form of legal capacity because I'm rooted in these principles. It ain't no second guessing. I mean, I could do it off the top of my dome. I don't even have to think about it.
Are there any other questions? Let's put any other, maybe somebody having a scenario issue that they're dealing with. Any questions, comments?
Come on, man.
I have a question.
Okay.
Can you all hear me?
Yeah, we can hear you.
Peace. This is Sister Najia. You know, in my experience, you know, as I'm slowly learning about the presentments, and for those that I know that are notaries, they aren't aware of the services or their authority to do a presentment. Or some will just, you know, deny if you offer or you ask them if they can present as such. Do you think it's because of the liability that may be posed on them?
No, most of them just not educated about notarial presentments. Most people don't know about it. I mean, most of the notaries don't. That's why, like, I try to get personal with notaries. I got a few notaries that I personally work with that I teach. information to, and they're like, okay, we willing to do this.
But keep in mind, you taught them.
Right.
That's
Right. I mean, and that's what
you
I was
teaching them.
concluding to. I was concluding to. I just think they aren't aware of it, most of them.
Yes.
Okay.
Yes.
Okay.
So I'm
Mhm.
gonna be honest with you. I make everything business. When you start talking dollars and you can show people that they can make money doing what they're doing based on their notary status, they'll be like, oh, okay, I can make some money. Yeah. So I try to, it's a lot of things you have to do. I try to meet people where they at a lot of
Mhm.
times by understanding how to engage the conversation, because if like the stuff that I just know how to win cases. I know how to do a lot of legal stuff. I'm very good at documentation and doing those things. I'm very good at it. That's why when we deal with my case, it was laid out to a point where it was hard for them to deal with. And they still don't know how to properly deal with it. They're still acting, the judge told Mike, hey, I have no more jurisdiction. Please don't file no more motions. I have no more jurisdiction. Mike, you still here? He might be gone.
Now Mike's gone.
Right?
Bye-bye.
But the judge told him, hey, don't file nothing else. I have no more jurisdiction over this case. She went from telling him, hey, you didn't personally serve me, right? To, I don't have no more jurisdiction. Don't file nothing else.
Any
Right?
other questions, comments, questions or comments?
And he used affidavits. He used affidavits to support what he was doing. Like I said, look at what you filed, Mike. Look at how you presented this claim based on the education that I brought to the table.
Let me read this last this there's the conclusion. And I know it's read. I'm just put it for effect. Conclusion. Affidavits and notary processes are crucial fact-finding tools that offer credibility, authenticity, and transparency in both civil and criminal cases. Understanding how to properly use these tools and aligning them with legal standards such as due process and evidentiary rules can and the key is aligning them with legal standards such as due process and evidentiary rules can significantly strengthen your case. When applied strategically, notary acts and affidavits serve to boost your claims and challenge opposing parties, ensuring that your case is backed by credible and official documents. I'm gonna do a post on this statement, statement here on Facebook. I just took a snapshot of it and I'll just post a snapshot. Yeah. All right. So since there aren't any more questions, comments, or criticism, we'll end here. Thank you for this will be posted. I know you go ahead, DuPont. DuPont.
Yeah,
You got
I have one
go ahead.
statement.
No, go ahead, my man.
Make it quick.
No, you ain't gotta make it quick. Go ahead.
If we have a session just based on, can we have a session based on affidavit and motions so we can have a complete clarity on how these procedures work?
No, this is the session. Are you asking a question? Can we have one?
More in depth. A more in depth session.
Our king, DuPont is asking for us to prepare a more in-depth session on affidavits and notary processes. Is King with us?
I'm right here.
All right, so what say ye? We got a lot on our plate, brother.
Yeah, we do. We got a lot.
Man, we got a lot on plate. So let's what we can do, King, is we'll spend some time preparing that, but I know we got a lot on our, a
Well,
lot coming down the pipe.
but also they can look at how what Mike case, how the affidavit was used. In Mike case.
That's legal principles. That's using legal principles and drafting motions and pleadings. Session 4, part 1. That's session 4, and using legal principles and drafting motions and pleadings. Part 2, which is session 6 on the Moroccan Post Media YouTube page.
So if you look at that, like if they go to that first with the motions that we show the motions, right? And the affidavits in support, right? That'll give you a context, right? Or how to use it. And then remember, we're going to do a contract course class, right? Where people sign up. So
the spring of
we're gonna
2025.
talk about the various affidavits in there, like utilizing affidavits with contracts. So that these things are very important. So we're gonna try to get ready for that. And what I'm saying to you guys is that when you root yourself in this understanding, man, I promise you, it's like your legal whams is going to change, right? I know how to look at stuff, read it, see what's up missing in it, see what kind of cause of action, see if the cause of action in which they're claiming based on what they're trying to do is the facts existing, is the elements exist in there, right? Like the prosecutor didn't, if you look at the jury didn't decide Mike face, the prosecutor said, we ain't got enough evidence to prosecute. Mike didn't have to weigh the jury. Because sometimes the judge is the jury, and sometimes you have peers that are jury, right? But he laid it down so factual, so heavy, right? He didn't need to rely, a jury wasn't relied upon. The prosecutor said, we ain't moving on this one. We ain't moving on this one. That's not enough evidence. We're not going to act on this. Why? Because he understood what to do. And then he knew what to do to take it to the next level if they wanted to keep on with the BS. It wasn't going to go to trial no matter what. Based on my understanding, based on Mike's understanding, this is what we're doing with Abdullah. Based on what me and Abdullah is working together in harmony. I'm telling you guys, we're bringing you guys something that the Moorish movement has not seen. And we already showed you, we know what we was doing, right? Based on Mike's case. And the highway patrol still don't want to release his car. They're still acting belligerent after he won this case. And pretty much the court is not answering that motion. He don't have a court date. He don't have a hearing. He don't have nothing. Why? Because it's not going to be entertained because it didn't go through the proper channels in order to set up venue. In order for them to have a venue to be heard, it's frivolous. So the court is not going to hear that. This is what I keep trying to teach, and help everybody understand. So please attend these classes. We got contract classes coming up. Please attend these classes. I'm telling you, this is going to change your life. We're going to do a contract course. We're going to do a trust course. I'm going to break stuff down for you. I was talking to Abdullah about some stuff today that most people don't even understand. I'm telling you, it's too rooted in misconceptions. Nobody has took a live case, say, okay, here's a live case. Right now, it hasn't been resolved. Here's one right now in the movement, show where they did this right then and now. And broke it down step by step. And then discussed it. Ain't nobody did that yet. I haven't seen the group do it. Not one. Me and Abdullah is on the same page. So I appreciate everyone. Just go back and watch a lot of the videos and then get up to speed. And we're gonna, I'm telling you, and we got more to come.
We won't have another session for about a month, King. We got to prepare for this seminar. Our brother Mike Cal reached out to us. I said 2 days ago. He has about almost 100 people. But we're gonna have to eventually go to Charleston, South Carolina, in a couple months. Like I said, he's a moving shaker. Like I said, he reached out to me 2.5 years ago for the first time. And he's just been very impressed with these educational sessions. So he reached out to me, and so we're going to be bringing them into this Moorish movement. We're going to be bringing them into what we're doing. You know,
We're trying to get back into the road of sovereignty. We working on the road of sovereignty with the outreach, right? These are things that is necessary. I need y'all to understand, y'all need to take this seriously. Why? Why am I talking like this? Because it's necessary, right, for us to have our own political legitimacy. If we don't do this right, Abdullah said, we're doomed. We are doomed.
Hell yeah.
We are doomed.
Hell yeah.
We are doomed. Listen to what I'm saying. We are doomed. If we don't take this serious, right? I got a petition I'm circulating around to form a permanent population. There's a nationality petition, rights of the Declaration of a Child, right? Quasi is, listen, attend this. I'm telling you,
Sister Sasha Ill, myself, and then we have brother Rahim Abdullah Bey. He's gonna be actually he was asked to be part of the Human Rights Human Rights Commission. Human Rights Commission, Regional USA, International Human Rights Commission. That's tied to Scientology. Actually, Scientology was a major part of putting on the Human Rights Summit. So, brother Rahim was asked to be part of the International Human Rights Commission, Regional USA. And that's he's the director of Scientology. No, son, not Miles, not the one I gave you my certificate. It's another European that's based in New York. Miles Parker is the one who handed me my certificate. You see the pictures, but myself, his wife is on one side, he's on the other side. That's Miles Parker. This is another European whom I've not met. He's with Scientology and based in Harlem, New York. So this is growing. We have, so we're going to have our brother DuPont was at the Human Rights Summit. Rahim was at the Human Rights Summit. Brother Nakeem was at the Human Rights Summit. Sister Brother Monty and Sister Sasha Ill was at the Human Rights Summit. And so we're going to have a much greater presence, and we're going to show them work. We're going to show them work. We ain't going empty-handed. We're going with a big behind 500-page booklet, binder with pictures upon pictures showing what we've done. That's how you get people's attention. You got to do stuff. You don't want to go there. We ain't going there saying what we're going to do. We show them what we have been doing, not we're going to do. We ain't going there saying we're putting this together. We go in there, we have put this together. This is what we've done. We launched this a year ago. We were doing this 5 years ago, 10 years. We're coming like that. You get DuPont, you're going to see the effect, DuPont. DuPont, you were there this year. DuPont, you're going to see the difference from this year to next year. You're going to see the difference. I said to you that same weekend when you were there, I said you was in New York. I said, DuPont, and you came back. And I said, when you came back, we went back to Los Angeles. I said, DuPont, this is when we do this, watch the effect. Watch the attention now. Because we're going to talk about what we've been doing, what we're doing, and the huge network. That's different. And we're looking to have about at least 50 plus conscious Moors there. We're wearing turbans and fezzes. We're serious. We're serious. We are focused. We're serious. We're determined. I want to give a special acknowledgement to Sister Pacola Lee Kusar.
Ain't you a grown man? Is it 20?
The June. It's already out. The date's already been posted for 2025. So I want to give a special announcement to Sister Pacola Lee Kusar Ill, who's on with us, and she's been with us for 4.5 years. Terrence has been with us since December 2019. DuPont and Stern Ma'at, Stern Bay and DuPont Bay, they've been with us since June of 2019. And they were part of the original caucus. And Sister Pacola and Terrence joined us later. So so I definitely want to give a special acknowledgement for sticking with us, through thick and thin, through the bads, through thick and thin. So I definitely want to give y'all props, because it has not been easy. A lot of work, and we've been sticking with it, and you're seeing the value of sticking to it, having stick-to-itness. So I want to thank y'all for not having the microwave mentality, for not having a popcorn mentality. Y'all been there. Ride and die. King joined us 2.5 years ago. Viceers and I have known each other for over 20 years. Amanda came to my etymology. She's one of my etymology students, traveled from Florida, stayed here in Philadelphia for about 3 months. Amanda stayed for about 3 months here in Philadelphia. She took the etymology class for the first time in the fall of 2019, was broken up into 2 5-week courses. Where when I first started teaching etymology at Temple University, Pan-African Studies Community Education Program, it was 12 weeks classes. And then they reduced it to 10 weeks. And then the director, who since retired, she decided, well, let's break it up into 2 5-week courses. And so Amanda stayed for both of them. So definitely Shem Malachi Bey. As I said, I gave Shem Malachi Bey a hug yesterday. So King joined us 2.5 years ago. And I want to definitely, give him his great props and agreeing to assist in the teachings. So this is great. Brother Kono Bay, I reached out to him 16 months ago. He answered the bell. He's working on his book. But Brother Israel, who's been posting PowerPoint presentations and points on YouTube, on Facebook. He's actually taking the lessons, legal fact-finding tools he presented 2 weeks ago. He's posted them on his on Facebook, tagged about over 100 people. So, and I said to him today that this is for 31 years, this is the most developed that I've seen this movement moving in the right direction, led by Shem Malachi Bey, and giving proper concepts. So I definitely want to, you know, and I'm saying led by Shem Malachi. I'm saying that. I'm saying led by Shem Malachi Bey. Nobody has to, I'm saying that. Remember, I spent 25 years from age 25 to age 50 in misconceptions. So that's why I'm saying led by Shem Malachi Bey. Because nobody was, all right. We know the misconceptions out there. We got to state. Nobody was saying that until Shem. Just hear me out. Nobody was saying state nothing. Nobody was saying we got to state. Nobody was saying that. Nobody was saying we got a flag and a seal. Nobody was saying that until Shem Malachi Bey. We know they still got misconceptions. But the fact that they've moved away from that the United States Constitution is the Moorish Constitution, they've moved away from that. I know they're still in misconceptions. I know it. I know they don't got a state. I know that. But it's because of Shem that they at least moved into the area of international law, moved into the area of try to reach out to the United Nations. It's because of Shem. We know they're still rooted in the misconception. They ain't got it right, but they at least moved away from that. That this is the Constitution of the Moorish government. That, you know, it's because of Shem. Shem put this Moorish movement on the right track. And it's because of him that now I can reach out and teach tens of thousands, hundreds of thousands. It's because of him teaching proper conscience. I'm going to give this man his due. I'm going to give him his props. It's because of him. I'll acknowledge Drew Ali for what he did. But I'm going to acknowledge Shem Malachi Bey for what he's doing. This man's going down in history. And I'll end on that.
I want to also acknowledge Brother Kenneth Bey, Najee Bey, right? Special honors to my brother Akuno, who did a marvelous job with his stuff. I want to acknowledge Amanda, Rasirius, Israel, Brian D. What is that? Stan Bay and Curtis Thomas. I don't know how you say Uram. I see a lot of I see a lot of y'all have been some of these names I've been seeing some of these names on the post. So thank you guys for showing up and sticking around and getting this information. Believe me, if you stick around long enough, it's going to stick like glue on paper. And once it sticks, you're going to be able to run with it, right? So I just been doing it for a long time, and I dedicated my life, and I want to give special honors to Abdullah. I want you guys to understand something. Abdullah don't have to do this. He went to school 6 years. I want y'all to understand the time he went from K to 12 and then spent additional 6 years in a particular field of study. He left his passion, his education, to say he was passionate about this, to teach his people something. That is very honorable, right? I need y'all to understand that. I don't care about, he took his time. I want y'all to understand time is one of the most important commodities that we have. He sacrificed, because he could be somewhere making some decent money, some good money. I'm gonna say good money. He don't have to be doing this for us. He can be driving him a Mercedes Benz, right? Waving at the people. Hey, going to class, teaching in various schools. He don't have to do this. So when I see a man who sacrificed his energy, his time, money, everything to come and educate the people, that's very honorable. That's applaudable. Very proud. Right. I want y'all to know a little bit about me. I sacrificed 15 years to learn this information, and I'm giving it away to the people. I need you guys to understand the importance of what we're trying to do to connect these dots, to move into political legitimacy. This ain't got to be a long, lengthy process. We got the right people. Shim, Abdullah, King El Bey, and us here. We're rooting ourselves in the proper concepts so now we can be politically recognized. So now we can go across the world. Hey, you guys want to be diplomats? Go over there flying to China. You want to go fly over here. We got business to attend. So let's get down to business. Let's stop playing. Let's get down to business so that we can be recognized and bring our mother out of her coma so she can give her children a hug. She can say, thank you, my children, for restoring me, bringing me out of my coma. I yield.
All right, my brothers and sisters, we'll end here. Thank y'all for joining us. This is the Moorish Investigative and Research Committee. This is the 7th session, September 28th, 2024. I guess we'll come back on another month because we got, we have to prepare for a seminar, we're dealing with people in South Carolina, Charleston, South Carolina. So we got to prepare for that. So we'll be back on another month. All right, so thank you for joining us. Peace, everyone.
Peace.
Islam, peace.